Privacy laws generally apply to entities that conduct business in the state or provide products or services, or maybe both, that target consumers within the state. Where the laws tend to vary, for example, though, is how they define certain things. So they might define consumer differently, or they might define personal identifiable information differently, or the threshold amount of personal data that an entity must control or process might be different. The threshold annual revenue that the entity derives from the sale of personal data might be different, just to name a few. And next, each law provides certain rights for consumers to take back control of their personal data. A lot of these are modeled off of the individual rights under the GDPR that Caleb just mentioned. So it's important to keep in mind that that's really the underlying goal of these privacy laws, is to protect the privacy rights of the consumer. These rights typically allow consumers the right to request access to their personal data or delete the personal data they provide, etc. Finally, it's critical for businesses to be aware of the consequences that they might face for noncompliance. So a data protection assessment is required for a processing activity that would present a heightened risk of harm to consumers. So this could include processing data for the purpose of something like targeted advertising, processing, sensitive data, selling personal data. In these instances, there must be documentation of each of the processing activities. In the news, we've had a lot of talk about Washington's privacy law. So the state of Washington was the first state to enact a comprehensive health data privacy law in the US. This law specifically focused on the collection of consumer health data, with a definition of consumer health data there on the slide. This law requires opt-in consent. So that's at the beginning, before data is actually collected, you have to opt in and say yes to that instead of opting out on the back end.